श्रावण महीना है, लोग काफी कार्ड खेलते हैं। इनका मेन पर्पस एंजॉयमेंट है, नॉट ए प्लेइंग कार्ड नॉट फॉर प्रॉफिट। कोई जो घर है और जो प्लेस है उसमें से कोई रेवेन्यू कमीशन और कुछ कमाते नहीं है, तो इट विल नॉट बी कंसिडर्ड एज ए गैम्बलिंग एक्टिविटी. So you need not worry about the police or anyone coming at your place, as you are worried about some uh, liquor activity when you're doing it. You do not worry about when you are playing cards. Don't worry that police would come and arrest you. This is the latest judgment of Gujarat High Court. I'm going in detail of this case, but one of the fundamental activity premise on which Mr. High Court, Mr. P.M. Brown has given a judgment, the High Court judge, learned High Court judge, did not give because there is no commercial activity done from the premises. Hence, the activity was quashed. Okay. Now I'm going into the detail of the judgment. But one fundamental, playing cards at home for no profit, no major thing, do not worry. Just go and play. I'm saying Nitin Pathak, say Nitin Pathak blogspot.com. Okay. Now I'm going into details of the case. This is my blog where different subjects are taken. In Gujarat High Court, the recent judgment said that Gujarat Prevention Gambling Act 1887, unless authority can prove that premises were being operated as a profit-making undertaking. In a significant judgment in 2018, a raid was conducted. High Court quashed the FIR that mere presence of playing cards and a cash in a privileged home is not enough to invoke the Gambling Act. The case stems from a police raid at flat in Ahmedabad satellite area in 2018. Acting on the information that gambling allegedly being police raided the premises and detained 5 individuals who were found playing cards. The case and playing cards were seized during the operation. An FIR was registered at Anandnagar Police Station under Section 4 and 5 of the Gujarat Prevention Gambling Act. The accused later approached the Gujarat High Court seeking the quashing of FIR, arguing that playing card at a private place, private residence, could not automatically transform the property into a gambling house. Part of the contention of the ground that this is not a gambling house. Profit element is missing, as High Court says. Hearing the matter, Justice P.M. Rao observed that a key requirement for establishing an offense under Gambling Act is a common gambling house operated for financial gain. The court noted that a property can be classified as a gambling den only if owner or occupant receives a charge, commission, fees, or any form of monetary benefit from allowing the gambling activity. According to this judgment, police complaint contained no allegation or evidence suggesting that occupants were making money out of these premises by playing cards. Without proof of such financial, the essential ingredient attract of gambling act is missing. The court questioned the speed of the research warrant. The High Court also raised the concern over the manner in which search warrant was obtained. According to the records, police secured the warrant and carried out the raid within just 23 minutes of the receiving information. The court observed that such has raised a question about whether the competent authority had conducted an adequate scrutiny before authorizing the search. It further pointed out that FIR itself does not specifically prescribe gambling house, weakening the case. Important clarification on private games. Referring legal framework governing gambling offense, the court emphasized that social card game played among the friends does not constitute criminal act. Unless investigators establish that premises being used for a common gain, solely playing card and cash does not amount to a gambling activity. The High Court ultimately quashed the FIR. At our place, this is a forum in which we are taking a Claude AI ecosystem. 4 lectures are already taken. Next would be on 18th and 20th. Join through Nitin Pathak blogspot.com. There would be a Google form. You fill up the Google form. Your Zoom link would be sent, or physically you are invited to attend in the physical. Claude AI is going to be the time of the match. everybody who is not knowing AI will be out of the game. So please join and learn something on AI. And there are so many past presentation is available also on blog. There is generally a belief that under Section 54 or 54F, when you do not have a position, you don't have a documentation, no full payment is made, you will not be entitled to have a capital gain exemption from selling a house or selling 54 of any other property, any capital asset. You will be entitled to capital gain exemption under Section 54, 54F. But this judgment clarifies that in certain circumstances, CBT circular and High Court and Supreme Court judgment is available, by which even if you don't have a position, you don't have documentation, or did not make a full payment, still you are entitled for the exemption. The ROC, when you're dealing with the company, there are so many formalities to be complied. Even if there is no mala fide intention, still the company has to pay 5.5 crore penalty to the individual, promoter, director, and a company. All were made liable to make a payment, even if there is no loss to anybody on the basis of certain action is taken. More, you can join the blog, say Nitin Pathak, blogspot.com. Thank you.